So what happens if you die without an estate plan? All of us make plans that are based on the possibility that a specific event may occur. Many of us carry more than the minimum required amount of auto insurance because we recognize the possibility that financial loss could result from an accident. And since it is 100% certain that each of us is going to die at some point, you might think that everyone would have an estate plan. The fact is, though, that that's just not the case. If so, what happens if you die with no estate plan? If you own property jointly, that property may pass automatically to your joint owner upon your death. If you have an IRA or retirement plan, or you own life insurance, funds may pass automatically to your designated beneficiaries when you die. Similarly, property held in a trust may pass automatically to a designated beneficiary. In general, however, property will pass according to state intestacy laws. These laws govern the disposition of property when someone dies without a will, or with a will that doesn't account for a portion of his or her estate. Let's say you die leaving $5,000 in a savings account. Who does the money go to? Without instructions from you, the money would go to the person or people that your state's intestacy laws say it should go to. Intestacy laws vary from one state to another, but here you see a typical pattern of distribution. 50% of the property goes to the spouse and 50% to the children. Remember, it may be different in your particular state. The biggest issue with intestacy laws is the fact that your actual wishes are irrelevant. Let's assume that you live in a state that has intestacy laws patterned as shown here. Without an estate plan, regardless of your actual wishes, for example, let's say you want all of your property to go to your spouse and none to your children, your estate would be divided between your spouse and your children. There are many potential problems with allowing your property to pass this way. For example, the distribution pattern imposed by your state's intestacy laws could result in disputes among your heirs, and higher overall taxes might be due. Intestacy can be particularly problematic for unmarried couples, since intestacy laws generally will not include an unmarried partner in the distribution of property. There's a simple way to avoid intestacy. You can create a simple will. How many people that are watching this right now have a will? Well, a will is probably the most vital piece of anyone's estate plan. A will is a legal document in which you direct how your property would be dispersed when you die. It also allows you to name an executor who will carry out your wishes, which are stated in your will. In addition, your will lets you name a guardian for your minor children. You can also create a trust in your will. You can use your will to accomplish other estate planning goals, such as tax planning. To be valid, your will must be in writing and must be signed by you. Your signature must also be witnessed, although the number of witnesses required varies from one state to another. These requirements are important because if you aren't careful, your will may be invalid. So see someone who is a practitioner or professional in this area to take care of this for you. And then the next one big consideration to having a will for some people is that the wills will have to go through a probate process. And we'll take a look at the probate process next. Most wills have to be probated. The wills vary from one state to another. The rules vary from one state to another, but in some states, smaller estates are exempt from probate or qualify for an expedited process. So what does probate entail? Probate starts with someone filing the will with the probate court, which will then oversee the estate settlement process. And usually the person named as the executor in the will does this. Once the will is filed with the court and it is validated, the executor can go about the business of settling the estate. This means collecting monies owed to the person who died, such as wages, paying any outstanding bills, filing final income tax and estate tax returns if they're necessary, and then distributing the remaining property to the rightful heirs. Usually, everything goes smoothly during the probate process, which typically lasts anywhere from a few months to a year, depending on the size of the estate. As long as the executor does what needs to be done in a timely fashion, there are no family squabbles. Nevertheless, some people may want to avoid this process. So let's take a look at how this could be accomplished. If any of these issues are important to you, then an estate plan can be designed to limit the assets that pass through probate, or you can avoid probate altogether. The major way property is passed outside of probate are owning property jointly or with right of survivorship, by ensuring that beneficiary designations are completed, that the proper forms are used for the types of assets that you may hold, such as IRA accounts, retirement plans, and life insurance, or by putting them into a living trust, or by making lifetime gifts. So in the next section, we'll switch gears a little bit and talk about the estate taxes.